Hello, welcome to the Law 360 GA channel. We're excited to have you viewing our content once again. We're bringing to you a new series of lessons captioned The Basic Technical Approaches to Tackling the Study of the Law. And today, we're going to treat our first episode on General Approach on How to Answer Problem Questions in Law. Please, if you're new here, don't forget to hit the subscribe button, put your notification bell on, like this video, and share to colleagues, friends, and families. We have more educative, informative, and exciting content for you all soon. Let us now turn our attention to our topic for discussion today. In law, there are generally three types of questions. These are writing a case brief, writing a problem question, and then writing an essay type question. All these three types of questions demand some form of technicalities, and it is what we're going to be treating now. Problem questions are different from essay questions. Problem questions are designed to test your understanding of the legal principles and your ability to apply the principles to various fact situations and legal issues rising from the fact presented to you. It is important that you produce a coherent, structured answer that responds to the various legal issues embedded in the hypothetical fact situation you are addressing. Problem questions are designed or crafted around a particular area of the law and specific legal issues. Your job is to identify those legal issues and address them as clearly as you can. Relevance is critical in answering problem questions in law, so your aim must be to identify the legal issues that are raised by the fact situation and apply relevant legal principles to their solution. Do's and don'ts. First of all, do not treat a problem question as an invitation to write an abstract essay about the legal issues involved in the problem. Again, application to the fact is essential. Do not fall into the trap of writing a general essay on the law relating to the fact and without applying the relevant principles to the specific issues raised by the fact. The dangers of excessive repetition and focusing on irrelevant points of law are high, and this is a very poor style. Then, avoid long introductions. Avoid introductions that are so general that they could have been written in an essay to any problem question on contract law. Such introductions do not answer the question set. Let's now move on to general organization. Point number 1. Read the fact thoroughly. Start with a fact. Read the problem carefully several times. Don't skim read. You must have a precise understanding of the facts, since it is the facts that will determine the relevance of any legal points you make later. Fact identification and organization is an important legal skill. If it helps, draw a quick diagram to explain the fact and the parties. Accept as true those facts that are given. Do not worry about how unlikely they might be. Do not assume facts which are not given, and do not ponder on what the position would have been if the facts had been different, unless specifically requested to do so by the question itself. For example, where the question states, would your answer have been different if, then the question follows. Point number 2, identify the area of law. This should usually be done in a sentence or two. The problem question deals with offer and acceptance, consideration, intention to create legal relations, misrepresentation, etc. You may refer to the specific aspects of the area of law you have identified, for example, with specific reference to promises to keep office open, counter offers, and revocation of office. Do not write an essay on the topic though. Point number 3. Identify the legal issues. Issues are legal questions which arise from the fact. They are the building blocks for your answer. For example, whether Kofi's letter of 1st June constitutes a contractual offer, whether party A's response to B's offer constitutes an inquiry or a counter offer. Ask yourself, what legal questions arise from the facts given? In some cases, there will be the broad ultimate question of whether there was a binding contract, but in addition, you have to identify all the sub-issues which will help you to determine or answer that ultimate issue. In identifying the legal issues, there are two factors you must consider. The first is ordering the issues. Consider the order in which you wish to deal with the issues raised by the fact, bearing in mind the need to present your point and argument in a coherent and logical manner. The legal issues involved will determine the order in which you deal with the principles and their application. For example, it is only logical to first determine whether an offer exists before seeking to identify whether a particular correspondence constitutes an acceptance. Similarly, you would probably identify whether the correspondence is in fact an acceptance before you look at whether it has been effectively communicated. The next is deal with one issue at a time. If there are several issues to discuss, you will need to deal with each issue separately. It helps when, as far as possible, you deal with each issue in a separate paragraph. Avoid jumping around between issues and mixing up the discussions on different issues, unless of course they are related. Maintain the links between the issues as you progress. Point number 4. State the legal principle that is relevant to each issue. State the legal principle governing each of the particular issues raised by the fact. This ensures that you focus on the law and will also make clear that you have identified the correct law applicable to the particular fact. For example, if you've raised an issue as to whether a particular communication constitutes an offer, you must define an offer and state the various features that makes a particular communication an offer. Then, you will be able to determine whether those features exist in the fact situation or not. Point number 5. Cite supporting authorities. This is critical. It is important that you demonstrate your knowledge of the law, so always give reasons for your views and provide authorities for legal principles and rules that you state. What is the source of the legal principle you have stated? If the legal position is unclear, explain the nature of the uncertainty and make suggestions on how it might be resolved, including your view of the most likely approach to be taken by a court. Point number 6. Apply the law to the fact. Do not simply state the legal principle and move on. You're required to apply the law you have stated to the fact. This means you must state how the law will apply in that factual context and assess what the likely decision would be on this issue. You must take a position based on the law and defend it. Point number 7. Avoid irrelevancy at all costs. Irrelevancy can lead to double jeopardy in that it detracts from what you have said and it leaves you with less time to say what is relevant and important, leading to an unbalanced and unsatisfactory answer. It also gives the impression that you do not know what is relevant, and that is an impression you want to avoid. Remember that if something does not advance your answer to the factual scenario before you, then do not say it. Tip: if you're asked to advise a named person in a problem question, then try to imagine that that person is sitting in front of you and is paying you for your time and advice. This should help you to focus on what it is that that person actually wants to know, and then explain and apply the law which is relevant to answering that question. Before we end our given approach to a problem question, let us take a summary of what has been discussed. 1. Read facts carefully to fish out the material fact. 2. Identify the area of law. 3. Identify the legal issues. 4. State the legal principle applicable to each issue. 5. State the authority for the principle you have stated. 6. Apply the principle to the fact and conclude. In all, answering problem questions in sequential order should be in 4-headed divisions, namely, the area of law, the issues, the applicable laws and analysis, and conclusion or resolution. Remember to head the respective divisions accordingly to make your work decent. Under the applicable laws and analysis, or where you will present the legal principles, it is best to give the principle first, followed by the authority, that is the statute, judicial decision, and scholarly view, and then analyzing the principles and the laws given to the issue you are resolving. Make sure not to leave out the relevant fact related to that issue you're resolving, because we are interested in seeing your appreciation and understanding of the principles, the law, and the issues, and how you will resolve the issues. Use the passive language rather than the active language in your work. Do not forget to number your issues and present your work neatly. Provide the general rule first before stating the exception in the situation, where the principle you're relying on has a general rule and an exception which you wish to rely on. It is important to note that this approach of tackling problem questions we have presented here applies to all courses but with few modifications with respect to certain courses such as the law of thought and others, and we shall address that in our subsequent videos. Thank you for your attention. Next time we meet, we'll bring to you how to prepare a case brief, how to answer an essay type question, and how to approach problem questions in specific courses that are slightly following a different approach. Visit our channel to view other exciting lessons. Do not forget to subscribe to this channel, write a comment at the comment section, and share to all and sundry. You can reach us via email thelaw360gh@gmail.com or WhatsApp 059 290 1176.